Welcome everyone. My name is Shauna Parks and I'm a contract instructor with Mount Royal University within the Department of Child Studies and Social Work. Today I have the honor of interviewing three phenomenal individuals regarding their experience with children's services, the legislation that is important to this work, and highlighting what social workers and social work students need to know and why this information is important. To our panel experts, thank you so much for being here today and taking the time to share about your knowledge and experience in children's services, and as well as the Child, Youth and Family Enhancement Act. Let me introduce you to our panel of experts. On my left, we have Chris Tortorelli. Chris is an assistant professor at Mount Royal University in the Department of Child Studies and Social Work. Prior to joining MRU, she was an associate director with Children's Services in Alberta, where she led portfolios related to mental health, addictions, disabilities, children who are medically complex, and the prevention of domestic violence. She also has significant experience in policy and practice across the domains of child intervention and child welfare. Welcome, Chris.
Thank you.
Next to Chris, we have Jonathan Nicholson. Jonathan is a lawyer, an expert in family law who recently retired from his lead role of director with Alberta Justice Family Law. Mr. Nicholson has extensive history of providing expert legal representation for children's services in the province of Alberta. He is a founding member and past chairman of the Canadian Society for the Investigation of Child Abuse. Welcome, Jonathan.
Thank you.
Last, we have Dr. Peter Chod. He's a professor at Mount Royal University in the Department of Child Studies and Social Work. He also serves as the program coordinator for the social work program. Dr. Chod is an expert in assessing parenting capacity with specialties in mental health, domestic violence, child abuse and addictions, and child and adolescent mental health, including maltreatment, neglect, and abuse, and these issues within the family systems. Dr. Chod is a consultant to Children's Services and has significant experience in research pertaining to the intersection between Indigenous peoples and the child welfare system. Welcome, Peter.
Thank you.
So let's start off our discussion today with Chris. So break it down for us, Chris. Who or what is Children's Services?
Sure. So in Alberta, Children's Services is part of the Ministry of Children's Services. So that really is centered in Edmonton as sort of its home base. And then across the province, there are smaller organizations like Calgary and Area Children's Services, Edmonton and Area Children's Services that provide the direct service to families in the community. So staff there, and a term that you're going to hear a lot is delegated workers. So those are caseworkers, supervisors, managers who are given the authority to act on behalf of the government and with respect to the legislation under the Child, Youth and Family Enhancement Act and others.
Awesome. Mm-hmm. So when we're talking about children's services, there's a number of intersecting legislations for people to be aware of. Can you speak to these?
I sure can. There's a long list, and I think for students, that list will be posted up on Blackboard for them. And they're not expected to know as social workers the intricate details of all of the pieces of legislation, but they are expected to know what they are and how to get support from someone who has a specialty in that area. So for example, the Mental Health Act is an act that Children's Services staff and social workers in general need to know, but they don't need to know the specific sections. They need to get advice from somebody, for example, in health, who has that detailed knowledge. Children's Services works with lawyers and lots of colleagues interdisciplinary to be able to do their job. So when I think about the legislation, I'll just kind of list them so you get a sense of what they are in terms of their names, but know that we will go through all of that in class, and you'll learn the Coles Notes version of that, or the basics of those legislation pieces. So there is, of course, the Child, Youth and Family Enhancement Act, often known as the Enhancement Act Or Peter, how do you say that?
Sophia.
Thank you. So in the community, people often refer to it as that. So you might hear any of those names. That is the largest piece of legislation that children's services staff work with, and they work with it every day. So they are experts in that legislation. It includes everything from how to report abuse to how to get involved, when to get involved with the family, why one would get involved, the options for safety, things like foster care and kinship care and adoption. So everything from the beginning of when one could hear about a child all the way to some options for different kinds of decisions around where they live. The Protection Against Family Violence Act is another significant one. And students will use that no matter where they are. You know, knowing these isn't just about being a children's services worker, it's about being a social worker in the community. So protecting children and victims, getting treatment for abusers, again, they'll learn more about that. Protection of Sexually Exploited Children's Act, Drug Endangered Children's Act, and the Protection for Children Abusing Drugs Act are all legislations that help social workers and families really take care of some of the most vulnerable children. The Family Law Act, which is about guardianship, and a number of other things, and Jonathan certainly knows way more about that legislation than me. Adult Guardianship and Trustee Act, which is about supports beyond 18. Family Support for Children with Disabilities Act. So that's really important and provides families with lots of options for support where they don't need to have the involvement of children's services necessarily. I mentioned the Mental Health Act. There's the Youth Criminal Justice Act, so working with youth that are involved with the legal system, trying to help support them in terms of their rights, the decisions that need to be made. Alberta Income for the Severely Disabled Act is one that, again, we come across in terms of young people who need support beyond 18. The Indian Act, which Peter is more expert in than I, and Bill C-92, which I believe he's going to talk about a bit. And the Immigration Act, as we become a much more global society. Immigration is something that happens regularly in Canada, and Calgary is the third or fourth most popular destination for immigrants. So that's important that students understand that as well.
Awesome. Thank you, Chris. So, Jonathan, this is for you. What are the connections between the pieces of legislation? Chris just mentioned all of these intersecting legislations, but could you maybe give some examples of how they connect and also to speak to how the legislation works? So specifically the Child, Youth and Family Enhancement Act. How does that work?
All right. Thank you. As indicated by Chris, there are numerous acts that involve the situation regarding children. The ones I'm going to focus on are the ones that are used in the court process or in litigation or contested matters. There is, of course, the Enhancement Act, which, as indicated by Chris, is the primary legislation that social workers or child protection workers will find them involved in. Applications under that act are, in most cases, brought by the director. There is a provision in there where individuals can bring applications for private guardianship orders giving that legal status. But aside from that, it is mainly the director that brings applications under that act. And the applications range from the least intrusive to the most intrusive ones. And the director's approach, aside from their mandate in these areas, is to attempt to use the least intrusive ones if appropriate. Those range from things like supervision orders where the child would remain in the care of the family unit, to temporary guardianship orders where the child is removed from the family unit with the hope that services can be provided in the hope that the child can be returned to the family within a reasonable period of time. And then, of course, the most intrusive where the application is for a permanent guardianship order sought before the court where the child is removed permanently from the family and the status of the parents and guardians is effectively terminated. Now, there are a number of acts that are related as well. For example, the Family Law Act, provincial legislation. I'm talking about provincial legislation here, not federal legislation. There are two areas within the Family Law Act that I find to be most significant when it comes to child protection proceedings. One is there are specific sections that deal with the determination of whether a person has or has not legal guardianship of a child. And we must remember that just because a person is a parent, that does not necessarily mean they have legal status as a guardian. For example, couples that are married do have legal status as guardians. There can be people who are not married, and one or both may or may not have legal guardianship. There can be other family members, aunts, uncles, grandparents that wish to acquire legal guardianship status. And I can think of two examples in that case. The director's hope is if you have to terminate the legal status of a guardian, which is in most cases are the biological parents who have that status, to still have the child maintain some type of connection to the family, extended family members, and possibly the biological parents. In that case, an aunt, an uncle, or grandmother, if deemed appropriate by the director, subject to determination of the court, may bring an application for legal guardianship. And if they're successful, then the director can terminate their application for permanent guardianship. That's a win-win situation in most cases. There may be situations where it's pretty obvious that the child cannot be returned to the parents and guardians. In order to thwart that application to the director, an extended family member or someone that's not even a family member will bring an application under the Family Law Act to obtain guardianship status and thereby prevent the director from becoming the legal guardian. So there's those two examples I think of, the most common ones we see. There's the protection of sexually exploited children. That application can be brought by the director or by the Calgary Police Service in Calgary. Usually it's brought by the director. If there is involvement, which is often the case by the Calgary Police Service, then it's referred to the director who brings the application. And so that focuses on whether the child is actively engaging in prostitution or there's a strong indication the child is about to start that type of engagement for various reasons. If the order is granted, it provides for a period where the child is in confinement while measures are put in place to provide expert assistance and therapeutic services to try and either prevent the child from continuing on to do so or prevent the child from engaging in that type of activity in the future. And as I say, this involves a period of confinement. And I take this time to point out that under the legislation in Alberta, whether it's the PSECA as it's often referred to, or the Enhancement Act, the legislation in Alberta that provides for periods of confinement, like incarceration, are not always found in every province across Canada. It's a very severe step to be taken. Their child would be put in a safe house for confinement, or alternatively, if it's deemed appropriate, if those concerns be addressed, the child would be returned to the parents. That doesn't happen that often, and often parents are very supportive of the director getting involved. There is the Drug Endangered Children's Act, and that application can be brought by either a police officer or the director. Okay. It's similar to the situation under the PSECA legislation where there can be a period of confinement, hopefully that service and assistance can be put in place to deal with the child's drug issues. It's if the child is not returned in 2 days, then it's deemed the apprehension under that legislation is similar to Section 19 under the Enhancement Act, giving the directors extensive status to deal with the matter. There's the Protection of Children Abusing Drugs Act, and that can be brought by the guardian. For example, we see situations where a parent can bring that application themselves, and there have been times when they take the initiative and do bring that application. Or the director, if the director has guardianship status already, they can bring that application themselves. And once again, the child is transported to a protective, safe house in that situation. So those are examples of legislation I see directly involving the court process and traditionally involving the director. As Chris has indicated, there are other legislation where you can find the director involved. And we can't forget the federal legislation, which is the Divorce Act, which determines custody and access of children. And that deals specifically with married couples. So those are some of the sections in legislation I'd refer to.
Great, thank you very much for that. Let's focus our attention towards the act that we're here to chat about further. So the Child, Youth and Family Enhancement Act for right now. I understand that at the beginning there's some important sections that guide the caseworkers, lawyers and other professionals as well as the court. So there's the section around matters to be considered. There's a lot of discussion around time provisions, etc. Jonathan, could you speak to these in the legislation?
Certainly, I'd be pleased to. And it's of note that there are over 130 sections in the Enhancement Act. So if I may, I would speak to ones that I consider most significant for caseworkers. That's not to say that every section is not important within legislation itself. For example, there's the initial sections that get the director involved, and that's where there is a community referral and results in the director making a decision as to whether to investigate the matter or not. The director may not decide to pursue the matter, and I can think of examples where, particularly when parents are involved in disputed and very acrimonious custody access battles, and they will try and drag the director in and marshal the director on their side so they can use that against the other party. That's very common. Very common. You'll see situations where one parent, particularly the mother, will make an allegation of sexual or physical abuse against the father. And the director will consider the referral or try and get as much information it can from community sources, or there may be a history of involvement with children's services prior to that. If the director considers that this matter is just specious and one person is trying to use the director against the other when there's no indication of any substance to the allegation, the director will determine they will not get involved. And there are sanctions there if someone uses a community referral that is unfounded and they're just trying to use it for their own purpose. However, if the director does conduct the investigation and does not say there's no substance, decides there is some substance to it, then they will decide what step to take. It may be that they'll take the step of applying for an apprehension of the child, or they may try and deal with it by not going that route, just a family enhancement agreement. The child does not come into the care of the director. Once again, the director will consider matters as to if they're going to get involved, what process and what level of involvement they take. It may well be applying for that supervision order, which I referred to previously, where the child remains in the care of the family unit, but the director provides resources and assistance to deal with the child protection concerns. Or once again, we'll go perhaps by way of a custody agreement. There could be a custody agreement by agreement of the parties for a period of time. If not, parents aren't agreeable to that, then apply for those orders, the supervision order, then the more involvement, the temporary guardianship order, and then finally the permanent guardianship order. So they will consider all those matters as to whether to get involved and what extent to get involved. If they do go for an apprehension order, these are usually done on an ex parte basis. Well, what do I mean by that? What I mean by that is notice is not given of the application. The director applies either in court, if it takes place during court times, or it can be by way of a telephone apprehension, if court's not in session, or sometimes there's an emergency application, either by the director or the police. It may be a situation where the police are there and they see we just can't leave the child here at this time. We've got to take the child right into care at this time. And they will get the involvement of the police in what's called CART, which involves the director as well, and bring the child into care. Then they will bring the matter before the court and give notice to the parents of the apprehension. After that apprehension, okay, then the application has to be brought before the court within 10 days and after the apprehension. The director has the opportunity within 2 days to make a decision. Okay, it looks like the family's got arrangements in place. We don't need to get involved further. We can simply return the child to the family unit, or alternatively, if it's from another province, to other child protection agency in another province. If you go past the 48 hours, then you've got that 10-day time frame. You've got to be in court and bring your application before the court. And what happens after that? Well, you get that initial custody, usually, when you come to the court the first time, and the matter is usually adjourned to deal with the matter of what's called initial custody. And that has to be not just brought before the court, it has to be concluded within a 42-day period. And what I'm trying to stress here is there are very strict time guidelines when you bring a child into care, because it's a pretty serious thing when you take a child out of the care of the parents and the family unit. And delay is not to be allowed any further than precisely necessary. And that's why there are strict time provisions in the legislation. That application for initial custody is brought. The director will present evidence through the delegated child protection worker. There can be an opportunity for the guardians to present evidence, but it's to be dealt with on a very short time period. It's not to be dealt with on like an extended trial, which can go on for long periods of time, weeks, months, even years, unfortunately. There are situations where sometimes the lawyer for the guardians will try and turn it into a full-blown trial, which isn't the purpose, and counsel for the director will emphasize that point. Okay. Now, there are various sections to be considered after that. One of the sections that you'll find is somewhat unique to the Enhancement Act is dealing with emergency medical treatments. And that is where either the guardians are unable to or refusing to provide medical care. That can be dental work, for example, or other surgical work. Often you see these matters dealt with in blood transfusion cases, where the objection to that is based on the religious positions or beliefs of the guardians. And those have to be dealt with very quickly. You can see those matters, if it's something that has to be dealt with in a very short period of time, they can be dealt with not in court, but actually at the hospital itself. I've seen situations where I've appeared before the Children's Hospital at 2 or 3 o'clock in the morning, and the trial is there. They have a judge there. Lawyers for the director are on an emergency call list, as are clerks of the court, and the judges. And it's set up in one of the rooms at the hospital, and evidence is presented there. It's like a mini courtroom to deal with that emergency application. As I say, prime example being the need of an immediate blood transfusion. After that, you have to consider the matter of right in custody, and this is something that's considered and it's considered along with when you do the initial custody applications. We have both federal and provincial legislation as mentioned. Now, dealing with matters of custody, and this takes place with guardians or married couples, that is dealt with under the Divorce Act. So what happens when you go into the provincial court, and that is a court of a lower jurisdiction? The federal court and the Court of Queen's Bench take precedent with federal legislation. Provincial legislation, like the Enhancement Act applications, they start off in the provincial court. So the legislation has to address how do you deal with a situation in the provincial court where the federal court under the Divorce Act may have already made a custody order. That's dealt with under Section 39 of the Enhancement Act, which says, notwithstanding an act made under any other legislation, the provincial court in the Enhancement Act takes precedent, and they can thereby make an order for custody, notwithstanding orders made in superior courts, such as the Court of Queen's Bench.
So Jonathan, that's different. That's a unique piece, right?
That is a unique piece, because aside from that, federal legislation orders take priority over provincial court legislation. Just like a Court of Appeal legislation would take priority over Court of Queen's legislation or provincial court legislation. And of course, an order under the highest court in our land, the Supreme Court down in Ottawa, is the highest court, and it takes precedent over lower court decisions. Thank you for that question. Then you get into Section 33, which indicates that there's a specific period of time within which the director can have custody of a child. If you're past that period of time, the director and the courts lose jurisdiction to make an order under the Enhancement Act. Now, if the child has been in care of the director for over 2 years, then the director is basically without jurisdiction to bring an application. There can be situations, of course, where the child has been in care under those temporary guardianship orders. And if you start an application for a temporary guardianship order, and let's say the child has been in the care of the director for 1 year and 364 days, that application for temporary guardianship order can continue on until it's concluded. Okay, so in effect, it could go on for, the court proceeding could go on for another year, and you'd actually have the child in care of the director for 3 years. Okay? But if the child has been in the care under, say, temporary guardianship orders for 2 years or more, then you're out of luck starting an application for a permanent guardianship order. Once again, an application where time and care has to be kept within a specific period, because a child has to have a decision made. Section 2 of the Act says any decision made in the child under the legislation has to be done as quickly as possible. You know, I find the Enhancement Act, and here's another thing that's unique. Sometimes judges find it very difficult to make a decision where you take a child out of the care of the director permanently. It's a hard decision to make. Some judges, in my experience, over 29 years doing this work, has been that they will try and delay a matter, hoping that people will come to a resolution and the judge won't have to make a decision. The Enhancement Act is the only legislation I know where there's a specific provision that you can appeal the delay of a judge making a decision about a child.
Right, so all of the Enhancement is built with the intention that it's in the best interests of children. That's why those timelines are there. So decisions are made in a timely manner.
And just to clarify, if there's an application that's made for a temporary guardianship order, the intent there is to try to work with the family to ensure that the young person can return home. But there are situations where that isn't going to be the case. What happens then?
All right, well, it's a good question. The section regarding temporary guardianship order says the court can grant an application for temporary guardianship if it can be anticipated that the child can be returned to the family unit, meaning that these child protection concerns can be dealt with successfully within that reasonable period of time. And thank you for asking that question, because it brings something else up. The director can apply for a supervision order or a temporary guardianship order. And the court can say, based on this history, I don't think that's the appropriate application. Notwithstanding what the director's applied for, I'm going to make a permanent guardianship order. Conversely, if the director applies for a permanent guardianship order, the court can say, that is too intrusive. I'm going to grant either a temporary guardianship order or a supervision order.
And Jonathan, we've seen the court do both of those things.
We have. And very often what the court will do is they will tell the participants when the trial starts that the court has that power. Often that's an incentive on the part of the guardians to say, okay, we're going to consent to the application. It's sort of a nudge, nudge, wink, wink. You don't have a chance here. Because we have what's called our judicial dispute resolutions on the Enhancement Act. That's where there will be a judge, usually a judge that won't hear the proceeding, the child protection worker and counsel for the director, the guardians and counsel for the guardians. And it's on a without prejudice basis, meaning that nothing said in that judicial dispute resolution can be used if the matter proceeds to trial. So there can be a frank and open discussion. Hear from the protection worker, counsel for the director, the guardians, and their counsel. And the judge will say, well, I've heard all this. Would any of you like to hear what I would do if I was hearing this matter? And everybody says, yes, because they want to know. And the judge can say, well, I think the director's intrusive application here is too strong. If I was hearing it, I'd make, say, a temporary guardianship order. I don't see that too often, but it has happened. Usually what you hear is the judge will say, I would grant the director's application for a permanent guardianship order. And that's an incentive for the guardians, the parents, to determine whether they're going to consent to this proceeding. Often what will happen is they'll consent if they can see some way they can have some form of access, even though there's a permanent guardianship order, and the court has the ability to do that.
So one of the issues, though, that happens, Jonathan, that I've been seeing much more of, you've been describing a very complicated process.
Yes.
But we're seeing more and more parents who, for varieties of reasons, either can't afford legal counsel or feel that they are somehow junior lawyers themselves and they can manage the case themselves. But we're seeing more and more parents represent themselves in court. What's that doing to the decision-making process?
That's a very good question, and the difficulty there is in a number of ways. For instance, legal aid has had a very challenging time with their budget. Their budget hasn't been what they need to cover all the people that really need a lawyer, and so you get situations where there's more and more self-represented litigants. The other difficulty there is when you get people that are self-represented litigants, they do not understand the court process. And what happens is because of their lack of understanding, because they're not lawyers, you can expect that, it serves to delay the process. And that's another negative too. So we're in that very difficult situation. And also the one you've touched upon is where you get some very junior lawyers there that just don't have that experience, and that serves to delay the process even more. I think I referred to that when I was talking about initial custody hearings, when some of these junior lawyers who aren't familiar with the process will treat it like it's going to be a full trial and try and draw it out. It's a difficult situation. I don't know what the answer is. The Court of Queen's Bench, has been dealing with this for a number of years. They had to take the step where they designated a specific courtroom to deal with self-represented litigants because it was just slowing the process down so much.
And what I've seen with that is that the judge takes extra time to explain procedure, to be somewhat patient with the parents to a point when they're self-represented.
And the other difficulty too is if you have an experienced lawyer, like when I had a case, I would really like to have the best lawyer on the other side because there was none of this difficult things that dragged the situation out. There's none of this silly stuff or unreasonable applications or things that would get in there. Give me the best lawyer for that reason. Secondly, if you have a good lawyer there for the parents, when they would meet with the parents or the guardians, they could explain what their situation was and give a very, very good, experienced legal opinion to them. They may say, you know, you really don't have a chance here of defeating the director's application for permanent guardianship. But if you give me those instructions, I may be able to talk to the lawyer on the other side for the director and see if we can do something with respect to some form of access that you may have. Of course, the thing here is, if the court's going to grant access to the guardians when the permanent guardianship has been granted, they can't grant that access if it will interfere with an adoption. Because the director's mandate and responsibility is to place children in adoptive homes if at all possible. So it gets very, very complex.
So this raises a really interesting issue, because we have provincial legislation that indicates that a parent could apply to have a permanent guardianship order reversed if the child has not been adopted.
Yes.
And so that's sort of one feature. And I think the other feature that is coming forward is the federal legislation, Bill C-92, which has an obligation for ongoing reassessment of the parent.
Right.
Where do you think that's going in terms of adoption and decisions of the court?
Okay, well, there are two areas there. The first one is the provision in the Enhancement Act that a former guardian after 1 year can apply to have the order terminated. If they are unsuccessful, then they can apply again after 2 years. I've always stressed to caseworkers that when you get that permanent guardianship order and the child is suitable as a candidate to have adopted, do not delay. Proceed immediately, because then once the child is adopted, a former guardian cannot come back and have the adoption order set aside. Okay? When the adoption order is granted, the permanent guardianship is terminated. But then that's the end of any possibility of a former guardian coming back and having the adoption order set aside. I was part of the committee on changes to the legislation that excuse me, dealt with that particular situation. And two of these subsections in that provision were, one, the former parent had to be in a position where they were able to care for the child. And the other one was that, one of the other ones was that it was the best interest to turn the child. It may well have been that the former parent was able to parent, but the child had attached strong relationships where it was and their placement, things like that. So I advocated that you had to meet both of those conditions if you're going to set that permanent guardianship order aside. And I'm glad they took my recommendation and made it that way.
So, and then we get into the federal legislation now, which is talking about ongoing reassessment of a parent where a child, an Indigenous parent, where a child has been removed and placed in other care. Where do you think that's going to go?
Well,
and I don't think we've seen any case law on that yet.
No, we haven't, and we have to see how the legislation works out in that regard. Of course, one of the provisions you're well aware of, Peter, I know, is Section 53.1, which is a fairly recent provision, as the provisions go, where it provides that when there's an application, you have to give notice to the band. And the band has the opportunity to come before the court and make representations, or alternatively, apply to be a participant and represented by their own counsel if they choose. If they're properly served and given notification, they have to appear the first time the matter is before the court. If If they don't appear on that first appearance, they lose that opportunity. So I see a lot of this coming out of where there was more and more concern, both federally and provincially, about dealing with the situation of the rights of Indigenous children and parents in the band. And we've seen this with that amendment to the Enhancement Act. We are aware that our current government made it a policy to deal with the situation about Indigenous children. So we have Bill 92, which deals, for example, Indigenous children, Métis, and their families, which is in line with the approach that our governments, federally and provincially, have been taking. Bill C-92. We have to see how it goes. It's something that the director and protection workers are going to have to bear in mind. It's ongoing assessment. Well, we will see how that goes. I think it's interesting. I think it's section 23 in the Bill C-92 that indicates anything done there has to be done in the best interest of the child, more so the parents. So we'll see how those provisions work out.
I think one of the other interesting things in Bill C-92 is, I think it's section 16, which has a hierarchy of placement.
Yes.
And in the hierarchy, the child's biological parents are given the first priority, and then kinship, and then
Band members.
other family members, band members, and then a non-Indigenous is the lowest priority placement.
Yes.
Yeah, and that's not something that I think is been operationalized terribly well at this point, and we're starting to have to understand that.
No, it hasn't been. It has been the policy of the director, of course, to look at band placements, not with parents, but looking at kinship in band placements, and if not, then individual members of the band or in that structure, but certainly not placement with the guardians or parents of Indigenous children. We've seen this go and be escalated through the years. It has always been for many years in the Enhancement Act, which was previously entitled the Child Welfare Act, that you had to consult with the band, and that you had to also consider the prospect of placement and the best interest of children with the band and members of the band. But it's come more and more to strongly approaches by both provincial and federal legislation, and you're right, we're going to have to see how it works out.
And I think this is combined with, we now have, I think most bands in Alberta have formally taken the position that they will not support an adoption of an Indigenous child into a non-Indigenous home. And I think it's fair to say the bands are coming to court with that argument as well.
Well, the bands have always been, looking at a moratorium placed on placement of children with non-Indigenous.
Does C-92 enhance that power?
I think it does. That would be my position. There's a lot of changes, as we all know, in Bill C-92. I mean, we're looking at the prospect of, the bands and that being able to make their own laws.
Yes, and we have now several dozen bands, some here in Alberta, that have served notice of their intent to do so.
That's right.
Yeah.
That's right.
And there is already one that historically in the interior of British Columbia has had that authority for many years. Yeah.
But you're quite right. We're getting notices of intent. So this is going to happen. It's not if, it's when it's going to happen. It's starting in that direction. I don't know where it's going to go. We live, as they say, in interesting times.
Absolutely. I think from a children's services caseworker, team leader, manager perspective, there's lots more learning that needs to happen around Indigenous culture, around Indigenous perspective, around family, and lots of bridge building and relationship building between the different parties that are involved in these decisions.
Yeah, and I think one of the other emerging issues that's going to matter quite significantly is the one that Jonathan's identified, which is First Nations across Canada are going to begin developing their own legislation. The Bill C-92 outlines certain principles that need to be in that legislation, but it doesn't determine what's in that legislation. So we can see dramatic variations across the country emerging as legislation becomes developed. And each of the nations are going to approach this as a national piece of legislation to their nation that would be applicable to all children, whether living on or off the reserve. The Métis nations have the same right as do the Inuit. So I think that if we look forward a decade, that the legislative structure that we're talking about today in respect of child welfare will be dramatically different in respect of Indigenous children. And it's important to recognize that here in the province of Alberta, for example, 7 out of 10 children involved in child welfare are Indigenous. In the province of Manitoba, it's 9 out of 10. The potential is that the legislative structure is going to create a place where Indigenous child welfare will no longer be the purview of a province. It will become fully the purview of nations, and the province could in fact shrink to be the smaller representative in the equation. And I think that may well be the intent. But equally, and Jonathan, I think that there are provisions of this new Bill C-92 that will ultimately end up in front of the Supreme Court, and that's about a decade process, isn't it?
I have no doubt whatsoever.
Yeah.
Absolutely no doubt.
And so we have, for the practicing social worker, we have provincial legislation that Jonathan's been talking about. We have this now emerging federal legislation, we will have a number of court challenges that will take, I think, a decade is a reasonable expectation before final determination. And even at that, I think one of the other issues that will emerge is what will be the court of competence of, for example, if the Piikani First Nation just south of us develops their own legislation with the intent of their own court. So those are other issues that social workers can anticipate are going to change, and they're going to emerge, and it's going to be a floating requirement for workers to stay in tune with this.
In tune, and to, as I said, reach out to the people that have more knowledge than they do. Social workers are very much generalist in whatever area they work in, with some specific pieces. If you work in addiction, or you work in child welfare, or you work in the family violence area. But reaching out and staying attuned to what those changes are through people who are, that is their job to know, that will be really important, because this is a change for everyone. None of us is going to know that legislation well. We need to rely on people who do.
And I think the other piece is these legislative changes are going to change what we do. So, for example, Section 53(1) of the Child, Youth and Family Enhancement Act that Jonathan's referred to creates a much stronger position than existed historically for the voice of the band. Bill C-92 ramps that up very, very dramatically. Bill C-92, along with has also said, so they highlight the section on best interest with the header, best interest of the Indigenous child. And so there's contextual matters, but it's also going to challenge us in terms of how we do what we do, because there's some principles in the legislation that speak to social work and how social work does what social work does. And so
I think, Peter, it requires a humbleness of social workers in their practice, especially with respect to child welfare, where maybe in the past it was more of a authoritarian decision-making approach. That's shifted over the last few years, at least here, but is nowhere where it needs to be in order to work in this new environment.
I think one thing that's going to be of note, and I may be speculating a bit here, is, but I think we're going to see more members of the judiciary comprised of Indigenous parties. I know here with our provincial court that we had one Indigenous member appointed as a judge. I believe it was Karen Snowshoe, if I recall correctly. So I think that's another trend which will be commensurate with the development of their own laws or legislation.
There's a parallel social force around legislation as well. So, the Truth and Reconciliation Commission in calls to action 1 through 5 has really laid out a requirement for what the provinces and the federal governments need to do around child welfare, and we're seeing variations in the moves that are taking place from that. But I don't think we can have this discussion in absence of Black Lives Matter, because what we still see is that the systems have systemic racism structured within them, and that also is within the application of law and with social work principles and social work theories. So, for example, we have the conversation in say, Manitoba, where 90% of the children in care are Indigenous, but we go into Ontario and we see an incredible dramatic overrepresentation of other racialized populations. We see in Quebec, La Belle Province, that the Premier has stated that Quebec is not prepared to sign on to the United Nations Declaration for the Indigenous People.
Yeah, and they've appealed Bill C-92.
And they've also filed an appeal of Bill C-92. So one of the great challenges is, I think, the relationship between social work practice and legislation is going to be tumultuous. So we have engaged as a profession in a social justice conversation where we feel that issues of racism and issues of historical trauma need to be addressed. And the judiciary and the legislation and the politicians are not marching necessarily in the same way that we are. I think that social work is probably a lot of work to do to repair, as the Truth and Reconciliation Commission has identified, and at the same time we have these other institutions who have not yet joined us in that conversation in the same way. And so the tension, I think, between legislation and social work practice over the next decade is going to be particularly interesting.
Well, and in fact, students ask us as faculty, what about other cultures? What about immigrants? What about other people of color? How do we think about them? How do we plan with them and for them in a different way as well? So I think students are...
Yeah, you've been dealing with that, for example, with the Sudanese community, because we have a large Sudanese community down towards Brooks and that's given a lot of challenges, I know, to children's services.
And I think it does, rightly so, ask us as a profession to take a step back and think through what we're here to do, what our perspective is, what our role is, what our ethics are, how we participate, but not necessarily lead with legislation. That's not how I perceive social work. Legislation is there to support some of the big safety decisions that need to be made, but how you do that does not have to be from an authoritarian perspective and should not be.
I think there's an interesting principle, though. Every piece of child welfare legislation across Canada, and I stand to be corrected on this, but speaks of the best interest of the child in some fashion. And even though best interest of the child actually is not it's a legal concept. It's not a social work concept at all, actually. But and it was started as a result of a legal case in the United States in the 1960s by Solnit, Goldstein, and Freud. But it's never been an established, researched psychological or social work principle. But it does say to us that your starting point needs in some fashion to be the best interests of the child. And courts will interpret that, and courts have interpreted that in in a whole variety of different ways. But if we think about that as a founding principle of legislation across the country, then we think about the parent is meant to not be the principal focus, but the parent is meant to be part of the principal focus, which is the best interests of the child. And how does social work take that from a practical, theoretical point of view into its interactions with families and child welfare, and utilize legislation to support best interests as opposed to supersede or interfere with best interests.
And you're right, Peter, the best outcomes happen when everyone can agree that the child is at the center of all the decision making, and when everyone can find some common ground around what that child needs and what is best interests of the child. That's where, if you will, the magic happens, where change happens.
I think one of the other things that legislation doesn't solve for us, and I think all three of us have seen this in multiple occasions, where the court will say to a 12-year-old or a 13-year-old, we're going to make you a permanent guardian of the director, and you're going to live at place X or place Y, and the 12 or 13-year-old or 15-year-old is going, not in my lifetime, and they exercise the right of simply, I'm going to walk. The legislation, the legislated perspective certainly allows for the director to come back and say, no, you live over here. But there is also a point where, from a realistic perspective as a social worker, there are community factors, there are community standards. One of the things when I was on the child intervention panel that the First Nations talked about time and time again is they had young adults to middle-aged adults show up at the First Nations saying, I believe I'm a member of this nation, and the First Nations going, we have no record of you, and having to figure out where and how can they support this person who has become alienated, but sees themselves as trying to understand their identity. So one of the things that's always, I think, important is the intersection between legislation, the best interests of the child, and the practicality of putting something into place that can be supported and is workable.
It's certainly complex. Peter, you talked about a couple of things, your involvement on the Minister's Child Intervention Panel, and you also touched on, we did talk a lot about Indigenous children and families, and a real shift in the legislation to respecting those rights. And why has that been significant? We know our students are going to learn about the impact of residential schools and the 60s scoop and the context of now, because what we know now is that there are more children, Indigenous children, and families involved in the child intervention system than at the height of residential schools. Can you speak a little bit to that, as well as some of the changes, the significant changes that you saw within the Act as you went through that panel experience?
Well, we made a number of recommendations. Phase one of the recommendations were done before the election, and I'm not sure where the current government is on phase two. But one of, I think, the principal messages that came across through all of the hearings that we held was that the First Nations, the Inuit, the Métis, felt disenfranchised from the capacity to make decisions for their own children. And they did link, time and again, to the historical traumas that move across generations. And I think inherent in that is that the First Nations, all of the Aboriginal communities that we spoke with, said you cannot separate the systemic racism from the practice, from the legislation. They are tied together, and that the systemic racism is historical for Indigenous people. And it goes back to the colonization of Canada. And so what they point out to is that the residential schools, for example, were a mechanism of the disbandment of Indigenous caring family and child caring systems. It was the dismembering of them. And so we've had students in the program who have talked about the trauma related to having grown up in a white home, for example, and discovering as their university students their Indigenous roots, and sitting in a classroom saying, this is the first time I've heard this story, when they hear the residential school story. But they sure know the 60 Scoop story, or they sure know the Millennial Scoop story, because they've been a part of it. The key factor in it is that the legislative response of Bill C-92 and the expansion of 53.1 in Sophia is associated with saying that structurally we have not solved the issue of the historical trauma, and that the legislation has served historically as a vehicle to separate, not as a vehicle to unify Indigenous communities across Canada. And so Bill C-92 is an attempt to begin to do that. Dr. Cindy Blackstock from the First Peoples Child and Family Caring Society has repeatedly said that Bill C-92 does not go far enough. And she has proposed something far more in-depth. One of the things that social workers really have to worry about is the interface between legislation, policy, and funding. And funding, so you can have a legislative principle. So Bill C-92 has many important legislative principles, and the First Nations are working with that. But at the same time, the federal government has offered no funding for the implementation of that legislation. Legislation without implementation mechanisms is far too often seen as window dressings, and the Indigenous people of Canada are saying, no, we're going to find a way around that, because we will not be beholden to a federal government who refuses to fund this piece of legislation. But legislation that is not funded is really a continuation of the assimilative response, because we're going to say in principle that you have this authority in the legislation, but we're not going to give you the mechanism to do it. And a number of First Nations have said, well, we'll find our own mechanism to do that. And it speaks again, though, to what we teach in social work. When we teach about legislation, we have to teach about policy, and we have to teach about practice that is consistent with the legislation, but is also consistent with the social principles of our profession. And there are conflicts.
Well, and one good example of that is the Family Support for Children with Disabilities legislation, that act, which is a piece of legislation that is accepted to be delivered on reserve, but there are precious little resources that will either go to the reserve or develop on the reserve that support it. So although kids are eligible and families could have this wonderful array of supports like respite and aids, etc., there isn't a mechanism in terms of delivery for that to happen. So, that, I think for me, that's a really good example of where intention was good, but the outcome is not.
So I think that one of the other pieces we need to talk about is, Jonathan has examined and cross-examined me in court on many occasions.
Me as well. Well, not me.
Yeah, and I must tell you, I'd rather be examined than cross-examined by Jonathan. But social work is also taking into court its methodology to assist the court in the application of legislation. So one of the principles that we have to also ask is, are we taking into court methodology and data collection that is inherently consistent both with the legislation as well as with social movements such as Black Lives Matter, such as the Truth and Reconciliation Commission, and such as emerging trends like in Bill C-92. So we have historically used assessment methodology that has been very Eurocentric and not Indigenous informed. And rightly, bands in their band consultations under Section 53(1) of the Act are saying, we're not prepared to have that anymore. So we will challenge, if you want to do an assessment, we will challenge the principle of the assessment if we are not bringing in Indigenous ways of knowing into that assessment. And that's an emerging piece we're going to see in the courts.
And in addition to that, Jonathan and I have both seen that happen in very specific and real ways around assessment of immigrant families. For the same reasons, right? And Defense Counsel is wiser, more educated and attuned to that, as is the bench, the judiciary. And so we are being, as social workers, as clinicians, held to a different standard that I'm not sure we're prepared for.
No, and I think that this conversation, one of the things that's been very important about this conversation is that child protection, if we come back to Crenshaw, who is an American lawyer, a judicial scholar, and she wrote about a concept called intersectionality. In Crenshaw's work, what really helps us is that you cannot take a system, child protection, which is a system, and imagine that system is operating in absentia of multiple intersections with other systems, judicial systems, legal systems, health systems, mental health systems, court, criminal justice, and so on. And so I think that the point of what Jonathan and Chris have been talking about is you take legislation, which is the vehicle for the application of the state's involvement, in this case in families, but it is designed not to emancipate the system. It is designed to empower, not a word I like, but it's designed to say the society says we need to protect children, and how do we do that? And hopefully we end up in the court as a last resort, as opposed to saying the court in the legislation is the lead. It is a structure for the delivery of service.
So Peter, you'd mentioned Bill C-92, and one question I've had, and you brought this up, is the matter of ongoing assessment. And over almost 30 years, my experience has been that it is often very difficult to get qualified people to do assessments, whether it's Indigenous or non-Indigenous. And I think that falls to where you say you can have the legislation, but what about the mechanics of the assessments? Do you have any thoughts on that?
I think we have two problems in the area of assessment. One is that we have not particularly done a great job of being inclusive in our social work education or social work profession. The truth is that we don't have enough Indigenous social workers. We don't have enough racialized social workers and psychologists and psychiatrists and pediatricians, and that becomes a problem. There's a second problem, and that is we also have a small percentage of the child welfare population who are incredibly litigious, and who are making it very difficult for people practicing in the assessment world to practice successfully, because they are really taking those professionals to court and professional bodies at rates that even a decade ago were not seen. And so we have to, I think, help people to develop skills that they can work in that contentious environment. And there's a lot of people who don't like to work in that contentious environment, just as there's a lot of people in the legal profession who the last place they want to be is in court. So we have to develop people who see that some of the more difficult and challenging parts of the profession are also an essential part in actually providing service to the child.
Through the years, I've had many of my colleagues, lawyers that are not in this area, ask me, Jonathan, how do you practice in this area all the time? Because it's not an area they want to be in, because it's such a difficult area, as Peter's indicated, so contentious, plus very often the facts are just so difficult and hard to deal with. And that applies to caseworkers too, and anybody that works in that area. It really does. Being contentious. When I first started out, you could see on the average a permanent guardianship hearing would take approximately 5 days. Now they can go on for 15, 20 days. Sometimes we've had ones that have gone on for years. It has just become that more and more difficult an area to practice in.
And at the same time, I think it's important that the professions, nursing, psychology, law, social work, medicine, and so on, recognize that if we are not prepared to step into the space that legislation requires to be addressed, then we abandon the most vulnerable people in our society.
We do, yes.
Thank you for addressing that. You guys have spoken to a number of really important considerations with the Act and with where we're going as well in children's intervention services, and definitely very important. All right, so I'd like to get us focused again on what the legislation actually looks like in practice for students. So Chris, walk us through what happens when an individual from the community, maybe it's a social worker, but maybe it's a family member, community member, etc. What happens when they call and make a report to Children's Services? They're concerned about their child. What happens, and then does Children's Services get involved every time? What does that look like?
Sure. So thinking about calls that come in, there are thousands of calls that come in every year to Children's Services in this province. And many of those are from police, from teachers, from health professionals, and then community members, parents themselves, people who call for advice, not knowing what to do, and people who call with really serious concerns about a child. You might be one of those people that makes a phone call as a student, or you might be somebody who's supporting someone else to make a phone call, or you might be someone receiving a call if you end up in a career at Children's Services. So what happens is that when you call in, it's important to have information ready. The types of things that they're going to be looking for is, what's the name of the child? Do you know their date of birth? Do you know where they live? Or do you know what school they go to? A way to sort of track where that family lives in the community. How do you know that child? What's your role? When did you last see them? Have you laid eyes on that child recently? Are you a teacher and you saw them in class, or they haven't been at school for a week and you phoned the house and were really concerned about what you heard? So it's important to sort of situate what you're going to say in place and time. And then details about what it is that you're concerned about, not your feelings about it and not assumptions about it, but what is it that you actually know? If a child told you something, what did they say? If you saw something, an interaction, say, between a parent and a child, what did you see? So being really specific. And then some good things that have shifted around child intervention or Children's Services practice is really looking at strengths. So they're also going to ask you, or you're going to ask the person who's calling in, what does this family do well? Who does the child have the best relationship with? You might not know all the answers, but where you do, it's really helpful in thinking through who else is in that child's network of support, who's in the parent's network of support, and who might be relied on so that Children's Services doesn't need to get involved. And then there are situations where a parent is doing all the right things. So let's say that as a parent, you had a babysitter, that babysitter hurt your child in some way physically, and you're calling because you want to get your child some help, and you're just looking for help to take the right steps. So are you going to the police? Are you getting them some support to see somebody to talk that through? So there's a lot of sorting that happens when a call comes in. Is it information? Is it just reassuring a parent or a family member that all the right things are happening and there's no need for Children's Services involvement? Or is there something where there is a concern about safety of a child, which is the bottom line with the Enhancement Act, and what further exploration needs to happen to sort through what that actually looks like? The other things that are really important is history. Is there history with that family, with that child or other children? What worked in the past? Who did they reach out to? The last time maybe grandma came and moved in for a while, and that really helped. So then can that be repeated? So every piece of information that helps to provide some guidance and direction will help Children's Services determine if they need to be involved or if they don't. And it's a good news story when they don't need to be. And that's not, the goal is not to become involved with every family. The goal is to become involved with the families who need that extra help and children whose safety relies on that.
Great. So just in practicality, phone calls that come in reporting concerns about children, not every call is going to be investigated. Not every time will a social worker or caseworker go out to visit a family or a child to do more investigation.
That's right, and not every time will it even be documented on the system. So if the initial conversation leads the person, the Children's Services person receiving that call, to believe that there is no role, then there is no documentation in the child welfare system about that either. Yeah.
That's helpful for sure. And so I'll put this question out to all of you. What's important to consider when making further decisions? You talked about safety considerations, but what's important to consider about the safety of a child when it comes to this legislation, why it even matters?
Well, there's a section of the legislation, and Jonathan lets you and I chat about that a little bit, which is called Matters to be Considered. And that details a series of 12 items, I think it is, something of that nature, that both a social worker and a court is to take into consideration. I think that the crucial question is the child, in what way is the child's best interest and safety going to be enhanced? And we know that the data tells us time and again, children will do best if they can be with family. Now, family may be kinship, family may be somebody else who sort of is family, and remember that for Indigenous communities, family is described very differently than it is for non-Indigenous communities. But children do best when they're with family, and the Act speaks to the idea of the preservation of family. In the matters to be considered, and what the Act allows in terms of practice, is to think of family in a broader sense, and to think of the preservation of the child to those linkages as being important. I'll take a slight diversion here. Jonathan's talked about adoption. Courts will often say, for example, for a child who comes from another culture, you need Mr. or Ms. adoptive parent to keep the child connected to culture. And they'll put in some kind of wording in the adoption order. But the reality is that the moment that adoption is over, that's entirely up to the adoptive parent, who has full
right.
control.
Yeah, there has to be a plan put before the court to consider when there are cultural aspects.
But it's not enforceable.
No.
And that's important to understand.
No, that adoptive parent becomes the parent, as a parent would have decision-making for any
Absolutely. But I think that the social worker needs to really be familiar. I mean, you know, Chris has talked about it's not the social worker's job to be the legislative interpreter, but the social worker really needs to understand matters to be considered. They really need to understand that.
Absolutely.
Yeah, I think Chris has raised a good point there when saying when the adoptive parent becomes the parent, they are the total parent. And I can understand the rationale for that because you certainly don't want to fetter the abilities of an adoptive parent. You want to make sure that placement has the best prospect of being successful. And so we look at that in that regard. And, you know, I often feel bad for grandparents because they've been parents and now they should be entitled to have the more fun of being a grandparent, but then they go and they adopt or get guardianship status. They've got to be parents all over and again. So I really do have a lot of consideration and empathy, whether it's grandparents or other non-family members that adopt a child. It's hard enough, speaking as a parent, we're all parents here, to raise your own children. I mean, there's a saying that being a grandparent is your reward for not strangling your children. And when you take another child in, that's really challenging. Particularly, you have to realize that a lot of these children may have come from negative environments that give them a lot of challenging issues for the caregiver. So there has to be a balance here. And I appreciate maintaining cultural contacts and things like that. That's extremely important. But you also have to set up your adoption for success. That's just a personal thought on my behalf.
I think that Jonathan's note is really, really crucial because we are really, I think, up against two particular opposing forces. One is exactly what Jonathan has talked about, and that is the idea of setting adoptions up for success. So that's, and as Chris identifies, having the adoptive parents in the role of the full parent. The opposing force is that in cross-cultural adoptions, we see high numbers, particularly those that arise out of the child welfare system. We see high numbers of adoption breakdowns occurring in mid-teens as the identity of the child starts now to become heavily influenced by their external and internal identity, which is part of what you do as a teenager, right? But now they look around the family and they go, so I'm this brown-skinned person and everybody else around here is white. I want to understand me as a brown-skinned person, and I want to be able to search that out and understand that. And there are some examples of foster parents, or adoptive parents rather, who have been brilliant in that. They have encouraged that. And then there are far too many examples of that we see in the literature, and I think the Brown v. Canada decision around the 60 scoop is a really good example, where we've seen thousands of cases where literally that racial issue has led to a breakdown. So that's the opposing force. And what I think courts are attempting to do is to find a balance in that opposing force, but I don't know that there is really a full balance.
No, you're absolutely right, Peter. And but it has led to a change in the practice for social workers over the years to when they're interviewing, working with prospective adoptive parents to address that issue. And if they find an adoptive parent says, no, I have no interest in doing that, I'm not prepared if I adopt this child to do anything to maintain the cultural roots of this child to its family of origin. So that's being addressed. We didn't see that years ago.
The other change, which is perhaps the easier change, if you will, than trying to shift how we work within all those legislations, is the practice of really searching out for family. So if we look historically across child welfare, the father's side has often been ignored. Because mothers didn't want the father involved, or because the father was not, in the child's life currently. Lots of reasons for that. But
well, let's be fair. A lot of the times, fathers were nothing more than the sperm donor and had no interest in being involved in the child's life.
Well, that is true. I think what we've learned, though, is that those fathers have families, and those grandparents and those aunts and uncles are interested.
Now
And
that's
so,
that's an interesting shift when you think about it, because, okay, so the father has no interest, but the assumption, therefore, that his family would have no interest is an erroneous assumption.
and so if we look back over time, child welfare across the world has not done a good job of that part. And that is something that, at least here I can say, is something that is more intentionally explored and in more in depth, in terms of more generations, in terms of a better look. So when we can have children who can't live with their parent, or parents live with family, then we address some of this issue of not being connected to who am I, which is that fundamental question, as Peter mentions.
And I think it is, the legislation pays attention to it, but the legislation requires the social worker to operationalize it.
Absolutely.
Yeah, and that makes me think of a point I always stress if I'm giving instruction to social workers, and that is the issue of the requirement of proper service when you're bringing an application. Very often in these situations, as we all know, well, almost invariably, it's because of negative family situations involving the father and the mother that lead to these child protection concerns. And very often when the director gets involved and the children are in custody of the mother, children are apprehended from the mother, the matter comes before the court. And you get to the issue of service, whether the father is a father and also a guardian. You get to the issue of the whereabouts of the father. And very often the mother, because of the acrimony between her and the father, will say, he's never been involved, he's not a guardian, haven't seen him for a long time, have no information where he is, don't know where his parents are in this, because they don't want them involved. And often because they go to court, the mother's going to be saying negative things about the father, but in turn, there's going to be a lot of dirt on the mother that's going to come out through the father. So they will tell this to the social worker, and the social worker goes ahead and only serves the mother and goes before the court and says, well, we don't know where he is. Mother says there's no involvement, when that's not true. Subsequently, the father can come out when he finally becomes aware of this, and it turns out he's a guardian. It can put a halt to the proceedings, not only for an application by the director, or if there's a pending adoption. I've always stressed that you are very diligent about getting any information about the father. Secondly, I've pressed, and this hasn't always been followed, if the mother's saying that, when you get her on the stand, you get her to say that under oath, because it's a lot easier to give that misinformation to the worker. But if you're up there on the stand under oath, you're going to be a lot more careful, or most people will. So that is always crucial to me, that you get proper service on all parties who are entitled under the legislation to be served.
And so talking with children about who those connections are for them, that's important. Genograms and eco-maps and the things that the social workers are going to learn through this program become great tools to be able to gather some of that information as well.
And that's the mechanism of operationalizing legislation. So Jonathan says everybody who's a party to this deserves to be given notice of this hearing. If you're only playing with half of that picture, you are depriving the child of certain potentials. You're depriving the child of understanding the fullness of their story. And so it's expedient to do this as opposed to this, but it's not good practice.
Chris, would you agree there have been situations I've referred to where the department has found out about the father's whereabouts, being able to assess his suitability, and it's been a situation where the director has supported the father obtaining custody of the children as opposed to the children coming into the custody of the director. And that's the best thing for the child.
Yeah, absolutely. I can think of a situation with a father who came back very late in the process, but that child has a connection with his father that you wouldn't see, I believe, with someone else, with a foster parent, or there's something about that connection between the two of them, which is really special and really positive. And, you know, he didn't have the skills to be a dad for a special needs child, but that doesn't mean he can't. And so supporting him to get those skills, to work with a specialized school, to be able to manage all of that, resulted in that child being with their dad. And those outcomes are so important, and we should not dismiss anybody without a good exploration of their
I'd like to take us just a little bit further down that pathway, and you and I and Jonathan have been involved in several cases where the family that we find is not in Canada. The family that we find is somewhere else in the world. And if the social worker hadn't been diligent in saying, who's in this network, then that child would have probably ended up in a foster adoption situation, which may well have turned out for the child.
Well, we don't. Sorry, go ahead.
But what we did see are situations where there was family in other parts of the world who were delighted at the possibility of looking after their children, their grandchildren, their nieces and nephews, and were very qualified to do so. But that's an example of the practice of meeting the court's the legislation's obligation around best interest, and searching for that family as part of that obligation.
And searching, I think, is the piece, right? It's not about gathering information. It's about searching. It's about that next level of work. And we should never underestimate what a family member will do to have a child with them. So a grandmother who traveled from the other side of the world, left her job, stayed here for months in order to build a relationship with her grandchild. You should never underestimate that, and I'm impressed always with what families will do for family. And that's just a different interaction than what strangers will do for children. And that's not to say that that isn't good too, but family is different.
Yeah, and so I think, to me, the walk-away message from this part of the conversation for students, you have to know your legislation in an operational way, but it's really you that turn that into practice.
Absolutely. Yeah, that's a great point. Thank you. Peter, let's talk about the parenting capacity, or assessing parenting capacity. You have extensive experience in this area. What does that entail, and why is it important to consider assessing parental capacity?
Well, what you're really assessing is the ability of a parent to either currently or with intervention successfully be good enough to raise their child. And if the answer is you're not presently good enough, what could we do? And good enough is a bit of a murky line, right? But what can we do to enhance your skills, or enhance something, or treat something that would bring you to the point of good enough? I'm sort of reminded of a young lady that I know who, if we had interviewed or assessed this young lady when she was 19 or 18, she was a totally out of control drug addict. Today she is the parent of 2 lovely kids, and it was intervention that. And I think all of us have had the experience, I'm sure Sean, you've had the experience too, where you're walking along the street and somebody comes up to you and says, "Do you remember me?" And you're going, "No, not really." But they say, "Well, I was so-and-so." And this happened to me actually just this week. I got a text from, or a Facebook message from a young woman I worked with 20 years ago. And she said, "I just happened to see your name on Facebook. I wanted to touch base. I wanted you to know how things turned out for me." And she's presently doing her master's degree. She has 2 children, long-term marriage. So I think that's the other piece, is in parenting capacity assessment, you're asking what's possible, and then how do we get to possible? There are occasions, and Jonathan has brought me in as a witness on several occasions, where there isn't a possible. You have an individual who is desperately deep into addiction, cannot find their way out of that addiction, but rarely do those come to trial, because I think most of the time the parents understand, it's me or the addiction, and it's my kid or the addiction, and the addiction wins.
Yeah. Okay, and I had a, well, not directly similar experience. Under the legislation, you can apply for what's called a secure services order. This is where the child is just, as Peter used the term, out of control, can be in drugs or other things, living on the street, and there's a risk to the child's well-being or others. And I can remember one particular girl, I won't use the name, but I had to go back multiple times to get continual orders on this girl. She was probably one of the worst cases I'd experienced in almost 30 years. I thought there's no hope. But she grew up, she turned 18, she became an adult, and her caseworker met her on the street one day and said, "I want to thank you. I'm married now, I have children of my own, I have a good life, and if it wasn't for you, I would have ended up dead in a dumpster." And it's things like that you hear that keep you going, that makes it worthwhile to do this very, very difficult work, where so often it can be so discouraging. But if we save only one, that's enough.
And I want you to hear something very important from what Jonathan said. And it's important for students becoming social workers. Legislation can be a hammer, but legislation can also be a tool. And what Jonathan describes with that application for secure services, that was a tool. And in that tool, that person had the opportunity to discover that there was a pathway. But it took persistence of the utilization of the tool. Legislation used poorly is just a hammer. But legislation with a particular clinical purpose that's clearly articulated is legislation that is being used for the betterment of the person. I think that that's the power of understanding the legislation, is how do I make it better? How do I use the tool that's going to improve this person's life? How do I utilize the services that arise from legislation to make it better? You cannot disconnect legislation from delivery. And because a child welfare worker at the end of the day has no authority to do anything in the absence of the legislation. But how do they use that legislation to not just be a police person, but to be a social worker?
And I think that's the power of the social work voice at the table, in the conversation, in the planning, is to bring that message to the table. So when we're working with police, we're working with health, we're working with justice, we're involved with education, we often are and can be that voice that speaks to how do we do this in a way that supports that young person, but also maintains their dignity and is intentional and has a purpose and an intended outcome at the end. That's, I think, a really important part of social work.
And I want people to understand that legislation isn't going to do the job for you.
That's absolutely a great point, and something that you've already addressed. Yeah. I'm curious. So we talked about. So there's a couple things that I want to ask about. When a young person or a child becomes, when an order is granted, a permanent guardianship order, does that always lead to adoption? And I know that we kind of talked about that. There's some challenges, of course, with Indigenous communities there, with proceeding with adoptions that are within non-Indigenous families. But so I'm curious to hear about that as well. And then just going through the process. So if a young person there's an order that's the permanent guardianship order is granted, what happens when they turn 18? And what's the process then? There's a variety of options, but I'm curious if you guys could speak to those.
So maybe I'll start and then ask Jonathan and Peter to jump in. So the answer to is it always adoption is no. And in fact, it's often private guardianship. That's certainly in discussion with bands with Indigenous children, a preferred way to go, because that, and Peter probably can say this better than I, but it fits better with the sense of community and family and not losing that child. Again, it's how that's done and who it's done and what the conversation is about that, for sure. And then there are young people who sadly stay in care in a foster home, in a group home, on the street. That looks many different ways depending on, whatever their personal challenges are, who age, what we call age out in care. So they turn 18, at which point there are certain provisions that are allowable for them, but most of what the Enhancement Act has provided for them up to that point doesn't apply. So they can have an agreement with Children's Services to provide them with some support, with some financial support, some people support from somebody who helps young people learn life skills and, manage work experience and getting a job or going to school. There is a bursary through the province that helps support education for kids that have been in care and aged out. And so up in Alberta, currently, those young people can be supported until they're 24. So that allows them to have a transition that would look more like my child would have in my home, although I hear that kids stay at home until they're like 35 now. But but finding a middle ground, right? That's the rationale for that, is that they can have that type of support to get more settled. And also, just to add a little piece about brain development, what we know about brain development more now than we did years ago is that there's more settling of emotions, that brain development and sort of cognitive ability becomes more settled around age 24, 25. So that's, again, a natural sort of time, gives them an opportunity for that. So
there's a really important thing about that, is the recognition in our society that 18 is not a magical date. Unfortunately, there are many places still in North America where at 18 you get sort of a plastic bag, your clothing, and and a goodbye. This transition period that Chris is talking about is a really fundamental opportunity in Alberta to ensure that the transition into adulthood looks less like a birthday and more like a process.
I like that that thought as well, and I'm curious about if a young person turns 18 and they're not perhaps interested in receiving services, perhaps they're just done with the system. Is there a timeline that they could come back to receive supports? How often does that happen? I'm curious because we know that there are young people that go through the system who are looking forward to their 18th birthday so that they can do what they want to do. And so what does that look like, and how often does it happen?
Maybe I'll say something first and then pass it over to Jonathan around sort of what the legislation says about that. But one of the practice pieces that social workers have in their toolkit is to have a relationship, build a relationship with that young person, and help that young person build relationships with people outside the system who can have a conversation coming up to age 18 and engage them in perhaps saying yes to try what that might look like. knowing that if they sign that agreement and then say no, that the answer then isn't to close the file, it's to have another conversation. And we've come a long way, where when kids used to, 20 years ago, say, I'm out of here, I don't want anything to do with this, the reaction would be to close that file. And now that's a conversation. And that's really an important shift. And having the young person have some control over what parts of that agreement they want support in and what they don't. Right? Yeah. Do you have anything more to add about that?
Well, I think it's indicative of how approach is focusing more from contention to negotiation or agreement or mediation type approach. The judicial dispute example in the Act is one thing too, and as Chris is saying, you don't close the file, you always keep it open, you try and work things out, and it has shown positive results in my thought. You asked about are adoptions always successful? Well, Chris has said no, and that's quite right. And I keep coming back to the time provisions. And as we all know, the sooner the younger a child placed in adoptive placement, the more chances for success there is there. For two factors. It'd be more from a younger age and more of their life as a minor. Secondly, the brain development thing that Chris is focused on, and also Peter. And there are other provisions in the Act too to ensure adoption. One is providing financial assistance too, which is critical because, as I say, if you've got financial concerns, that can put great stress on the family.
It's probably true to say that the poorest outcomes will be a child who ends up in unstable foster care. There's so much research that tells us that is not a good pathway for kids.
And I would add group or residential care to that, right?
And group care as well. So I think that when we look at the possibilities under the legislation, we look at the kinds of policy options that go with the legislation, what we're really looking for are solutions that are really associated with long-term stability for the child, and the less we are able to do that, the less likely we are going to be successful. But to Jonathan's earlier point, we can't give up either, because I talk about the 19-year-old who was a drug addict. Jonathan talks about the young lady who went through multiple secure orders. And one of the challenges I think that can happen in social work, particularly in child protection areas, is you can become cynical because you see so much difficulty. But I think it is important to recognize that as you continue to utilize the options available to you under legislation, your opportunities for intervention are still there. And I think that the fact that we all know people who turn their lives around in their 18 and 19 and 20 years of age, that possibility is not determined by chronology. It is determined by the continued availability of somebody who believes that change is possible.
And we have to remember too that along that continuum, that child is changing, but perhaps so are their parents. And so there is an opportunity maybe for some reconnection at a different stage in life when safety decisions can be made by a 16-year-old very differently from a 3-year-old. And so I think we have to have that perspective and belief that people can change. All people can change.
So how do we utilize legislative options available to us to support change in a way that is going to create the possibility of a different pathway? We can't create the different pathway. We create the possibility of different pathway, and legislation is a vehicle by which we can do that.
I just want to say something here that, I agree with Peter that one of the most tragic things is the placement of a child in a negative foster placement. But there are some fantastic foster parents out there. Absolutely. And I've had so many of them come to court and give their evidence as to the challenges presented by a child or more children they have in care and the job they've done, they are just super. I could not be a foster parent myself. I acknowledge that I could not do their job. And also, you know, I'm in the litigation area where there's confrontation on that. I deal with that. I deal with families where, you know, it's negative circumstances coming to children's situation and that, where it ends up in court, and you can look at permanent guardianship orders where children are taken away permanently from their children. But let's not forget, there are so many families that have problems and issues that Children's Services helps that never get to court. And so many people forget that. I see a lot of lawyers on the other side that take a very negative approach to Children's Services, and I say to them, you only see the small percentage that gets to court. You never address your mind to how many families the Children's Services works with them, and they don't end up here. They're invisible, but you
That's
should
so
never
true.
forget that.
And
That
I do
is
want
so
to put,
true.
I just want to repeat my caveat was unstable foster care.
Yes.
Or unstable
Yes.
group care, yes.
But you have a good point that the majority of the work that happens within Children's Services happens with families through agreement and support, not through court orders.
That, again, you guys have spoken to that too, that the ability of Children's Service to be able to work with parents in order to keep their child in their care, or to even help to address those concerns so that the children can come back to care. That's the focus of Children's Services, and I think that is absolutely important.
Well, and I just want to give a simple example. I happened to run across one of our graduates a couple of months ago, and she said, I'm really, really nervous. I'm going to court next week. And I said, oh, and how long have you been? She said, I've been with Children's Services 4 years. This was her first time going to court in 4 years.
Yeah. Anyway, you have to remember too that you hear the term permanent guardianship order. It's not necessarily truly permanent. We've had comments about how after a year you can bring an application by the previous guardianship person to have that reinstated, and then if it's unsuccessful, 2 years. There's also provision where they're having situations where the parent and guardian has worked with Children's Services after the granting of a permanent guardianship order, got their life in order, and the directors brought the matter back before the court to terminate. And there's
That's
nothing,
a celebration.
that is nothing I have enjoyed more than when I've had an application to do that. It is just wonderful to be able to do that.
Absolutely. So permanent is not always permanent with this legislation. Yeah, I think that's awesome. So we've kind of wrapped up the question portion, but I'm curious, just one last question. The focus of this interview is to be able to provide students with a real overview of the legislation and those intersecting legislations and stuff. But I'm curious, because our audience is first-year social work students, what advice would you give students moving forward as they're pursuing their social work journeys? What advice would you have for social work students? I'll give you a chance to think about that. Yeah, go ahead, Jonathan.
You know, often I'm asked, and the question is put to me, Jonathan, when do you start preparing for court? My answer is, the day you open the file. And if I asked any of these students why they went into social worker as opposed to engineering, accounting, whatever the question may be, they would probably say, I want to help people. I want to make a difference. I want to do good things. And when you get to court, and often these students will work from day one trying to help the family to have a successful outcome. And that's great, and that's what they should be doing. But it doesn't always work that way in spite of their efforts. And when they get to court, they'll get up there and they'll tell the history, and they'll give their history and their involvement throughout a file. And it's tough. because they've gotten to establish a close relationship with these people. Sometimes they trust them for good reason. Sometimes they feel like they're friends. I'm talking about the parents there. But you have to be very careful and always bear in mind that this matter, even though you don't want it to, can end up in court. And what is critical is that you keep good records and documentation. One, because it's of great benefit to you when you go to court to refresh your memory, because, 4 years involvement, as Peter's indicated in one example, can be long. It's hard to remember over that time. And you can have a situation where you're telling one story, parents telling an opposite story. Who is the judge going to believe? Okay? The one who's more credible, the one that's telling it most like the way it is. If you've got a good documentation there, file, you can refer to it, and the court will allow you to that. It's your notes. And the inference is, if you've kept those records in a chronological period over time, they're to be accurate. If you've put in direct quotes of what a parent has said, it's in those records, what they call contemporaneously at the exact time, in a direct quote. It's pretty hard for the other side to say, I never said that, in those contact notes. Secondly, you may turn the file over to someone else, and they're going to continue the history of the involvement in the file. It is a great assistance to them to refresh themselves as to the background and carry on in an appropriate manner, and also if the matter goes to trial. So it is critical to realize that this matter may end up in court, even though that's the last thing you want to do. Continue with your efforts, do your best, but be prepared.
And thirdly, a well-documented file may actually be the only source of information that a child who did become permanent guardianship will have on their history, and they can obtain it through information and privacy processes. So you may be actually documenting the story that the child in adulthood will draw upon to understand those roots.
I think that's really important, absolutely.
So if I might add to that, I would really like to reinforce the documentation piece. I have been part of teams that have done file reviews across the province. And if it's not written down, it didn't happen. And it doesn't matter how well you remember it. If it's not there, it didn't occur. So that's really, really important. When you leave your caseload, and it doesn't matter where you work, this is not about working within children's services. This is about working as a social worker. So if you're working in a community agency, your documentation is as important, because you might be called to court, or you might need to pass the file on, or you might get sick. And so the only record that someone has is what you have written. So I would really like to reinforce that for students. The other piece that I think is really important is this work is hard, and you need to consult, and you need to work as a team. So have people around you that you talk things through and who support you to be a better social worker.
One final thought. One of the things we did on the child intervention panel is we changed the legislation related to the child and youth advocate. So we broadened their ability to look at cases where things go poorly. And fortunately, statistically, things go poorly in a way that the child and youth advocate is going to be involved on a fairly infrequent basis. But one of the ways in which we learn about how child welfare and social work can be done better is by looking at the cases where things didn't go well. And so that documentation is key to that as well. So that when a child dies, for example, in the care of child welfare, we can learn from that child's death in a way that improves service. And so good records are also a mechanism by which we can do that.
Here's another example of importance of records. When a parent, guardian, goes to meet with their defense lawyer, they'll often color their story somewhat to make themselves look good.
And who wouldn't?
Well, of course, that's human nature. Yeah. Now, as counsel for the director, I'm under an obligation to provide proper disclosure to the other lawyer. When I do that, they have an opportunity to examine the record before they go to court. And if they examine the record and they see it's an accurate, consistent, professional record, and they can see that their client is telling them a story that isn't accurate, that puts them in a good, better position. One, they don't go to court and be surprised by the witnesses. They're not caught off guard. And secondly, they can talk some sense to their client as to whether they agree perhaps to a lesser order or to the order the directors are applying for. So there can be great benefit there.
A piece that maybe just sort of wind this up is that each of you as a social worker will develop a way that you practice in the area that you practice. That's really important for you to know who you are as a practitioner, and you'll learn that over time, because you can say in a court or to your supervisor, I always do it this way. This is my approach. This is how I do an assessment. This is how I meet with a family. This is how I do a genogram. This is how I gather information, etc. So that's important. And so paying attention to who you are and how you're developing as a practitioner is really important. You'll all do it a little bit different. And that be prepared, though, to evolve over time. And hopefully that's something that you've heard in this conversation today. Practice needs to change as information changes and as knowledge and evidence and research and stories about what's happened in communities tells us more.
Absolutely. Well, I want to thank you all very much for your time and expertise in discussing children's services today in the legislation. I think that this has been a valuable conversation, and certainly to students who are viewing this video. So thank you all very much for your time and knowledge and wisdom and expertise today. I really appreciate it.
Thank you.
Thank you.